Hello, can you please introduce yourself?
My name is Easy Harris. I'm a community activist here in Orlando and a disabled American veteran.
Okay. Uh, from the background, I'm Erwin Ironstone. How did we meet?
Well, Erwin, a good friend of mine, David Mack, knew you from Berry Law School, and he kept telling me about this guy that loves to sue judges. So I said, well, that's the guy that's right up my alley. And so I was probably asking him over a period of a couple of years, and finally he sent me a link to one of your YouTube videos. Then I contacted you through that.
Okay. I really don't like suing judges because uh, it's a fixed system and they're judged by other judges. And the only reason I might sue a judge is if I believe he violated the law.
That's a good reason.
Yeah. Easy. I'm going to move next to you and I'm going to move the camera into a slightly different perspective.
And by the way, Erwin, you got a great radio voice.
I've been told that before and I don't know why. But
It's that deep, sort of like New York accent, baritone voice.
as far as, any communications we've had, initially, in fact, this is the first time I've met you.
Right. Today in court.
Today in court. And I've never met you
In person.
before this. And you gave me a little history of what happened, and I won't say that the police lie or anything like that, but in crim law, when I took it, there was a Supreme Court case that related to how people can search, or how the police can search. And after the case, it said they couldn't put their hands in anyone's pockets. So after the case, the number of dropsy cases increased 70%. What is dropsy? That means the person they arrested dropped a bag of something, and it went up 80%. So there are some very good cops, and there are cops who lie, just as judges or prosecutors, and they're very, very good at it. And I'll let you talk. Today you were in court because, if you told me correctly, and you tell me why you were in court today.
Well, actually, my cases are pro se. I have about 8 cases from 2009. There are drug trafficking cases where I was arrested when I was a candidate for Orlando City Council. And as a result of being arrested on drug trafficking charges, I had to withdraw from the race. But I've been through, in the last 6 years, I've been through over 10 attorneys and 3 different judges. And if people think I have that kind of power to delay prosecution or to have that many lawyers or even judges for that matter, no, it's not me. But I will say is I've been blessed with the ability to that can read and write and know the law, and I really thank God for that. And
Well, I don't want you to say that because you told me about a motion that you put in. Who's the current judge?
but the current judge is Circuit Judge Mark L. Lupit.
Okay.
He's been a judge here in Orange County for 10 years. And what I mean by being able to read and write, for me what's important is that that when you're represented, and that you have a constitutional right to have an effective attorney, that means that you want to hold these people's, how they say, feet to the
Feet
fire.
to the fire.
And what happens is that, and people need to understand that when you have public defenders or generally court-appointed attorneys, about 80% of these cases plea out, even if the person didn't do the crime. And then you go to other places in this country, you find out the numbers are even higher. And I was looking at a study that showed that in New Orleans, Louisiana, that in one particular parish, the public defenders only spent 7 minutes per case.
One of the problems is public defenders are not paid very well.
No.
The other thing is they have very, very large caseloads.
Yes, they do.
And once they learn how to present actions in court, frequently they leave the public defender's office.
Yes, they do.
So they continually have a rolling group of lawyers.
It's
And
a shame.
the other thing, and on the streets, I didn't know this, they're called public pretenders.
Yes.
And one of the reasons is they're not given the money to prepare, they're not given the money to get experts, and they have to defend these actions with both hands tied behind the back.
Well, that may be true, but remember now, historically, when you have 8 out of 10 cases that go to the public defender's office, when they're settling these cases or plea bargaining, the lawyers that are attracted to this, as it were, putting their names on the list to be appointed to cases, I mean, they pretty much think it's easy. But when they get one of my cases, where from day one I said I would not plead to these charges, and I stuck to my guns. I nearly took actually did take 2 years community control, followed by 5 years. But the prosecutor said, well, I need to check with the agents. And then the more I thought about it, the more I didn't like that idea, because I'd always told people that if you didn't do the crime,
Don't spend the time.
yeah, don't settle for it. And so it was a long weekend, and I pretty much contacted the prosecutor and told him basically to reject the judge's plea. And I told him that in confidentiality. And so everything I told him in confidentiality, he went and brought it up in court. And that was just another issue that really showed me that I really couldn't trust prosecutors. Because if you tell someone in private, or if you even by email, where you said this communication is private, not to be revealed to anyone, they'll do just the opposite to make you look bad in front of the judge.
It's even worse than that, because any types of negotiations for pleas are not supposed to be presented in court.
Yes.
So that's one area where there was may have been prosecutorial misconduct.
I don't have any doubt. I don't have any doubt.
I mean, that's,
Yes.
I believe the law.
Yes.
Although I'm not an expert.
Yeah, well, no, I believe you.
Okay.
Because when you're having these plea negotiations, the public or the judge is not privy to that. That's to be worked out. And since I was pro se, that's between me and the prosecutor.
Okay, I want to just say one thing. I'm not an attorney. I don't practice law. Although I help people who can't afford an attorney, that means if they come to me, there's no charge, and I get overwhelmed at times. I edit papers if they write them. I teach them how to use the internet so they can do research. If they want to bounce that off me to find out if what they're thinking, I'll give them terms so they can search. Mm-hmm. And there are several cases, Supreme Court cases, that are controlling in this. And one of them is Johnson versus Avery, Supreme Court. Another is NAACP versus Button. And there are many more. But in Florida here, the Bar Association is so powerful that they'll bring charges of unauthorized practice of law, which is criminal, against anyone, even though two friends can be talking about it. And I think that has to be changed by the chief judge of Florida.
I just shake my head when it comes to Florida laws. I've been here 21 years. In fact, my mother and father moved away from Orlando in 1953. And 6 of us, I have 8 other siblings, 6 of them were born up in New York. And I think I come down here with a New York mentality so that when you see people laying down to the law, letting their constitutional rights being violated, and I went to school for paralegal. I do a prison and jail ministry, and the inmates often ask me questions about law. No, I'm not a lawyer. I'm not a paralegal, but I do the research for them and do help them with their cases. There was a case where Clarence Wheeler was convicted of first-degree murder and sentenced to 25 years to life in prison. And he was only 17 at the time, and so he was sentenced when he was 18.
You know what? I'm going to interrupt you because I want to really get to...
But the long and short of that was that I told the prosecutors that that case was coming back. The kid did not confess. They kept me out of the suppression hearing. And the DCA, the 5th, they overturned the murder conviction, and the kid ended up just taking 15 years. But the point about it, I can't stress enough that you have to make this personal. When your life is on the line, you have to fight like cat and dogs because you're a court-appointed attorney, and often the public defender is not going to fight for you. You know, it's between you and God, and certainly when God is on your side, if you truly believe, you'll prevail.
Okay, I'm going to ask you some direct questions. The last lawyer you had, she asked to be removed. Is that correct?
What happened was I had asked her to ask a judge if it would be all right for her to remove after we got the depositions transcribed. But the judge says, no, you have to withdraw now. We're not going to wait to. And so I saw how he was treating her.
So it was the judge who initially requested?
No, what he did was he didn't want her to wait until after the depositions were transcribed. Because remember, these are depositions from 2010 that hadn't been transcribed. This is 2000 right now. At that time it was 2015, December. So more than 5 years had passed since these depositions were taken and they weren't being transcribed. And she says, we're ready for trial. I says, there's no way we're ready for trial. So she says, well, I can request the judge that we do a Nelson hearing. I did not ask for a Nelson.
I have a question. Before you talk about a Nelson hearing, the judge held something called a Ferretta hearing.
Right.
Now, Ferretta hearings are based on a Supreme Court case called Ferretta versus California. And it had to do with a prisoner or a person, not even a prisoner, I think, asking that the judge, I want to represent myself. Did you ever ask for that? Did you know what a Ferretta hearing was?
I didn't know what a Ferretta hearing was, but here's what's important. And when you have for lack of a better word, you have a defective attorney or an ineffective. And to me, I really wanted to use the word defective. When you have an attorney that's not working on all cylinders for whatever medical reasons, I wanted this particular attorney off the case because the attorney was doing more harm to me than helping me. I would be better off representing myself, where she was on my case for 6 months.
That's something that you never ask. It's never to say you want to represent yourself, and I'll tell you why.
And I agree with you, but in this case, it was so extreme that when you see a lawyer literally shaken because she's being intimidated by the judge and she's having her own medical issues, for me, the compassionate thing was for her to withdraw. And so what I was able to accomplish during that month that I represented myself, a little bit more than a month, was that I was able to put out about 5 or 6 different motions and pleadings where she had my case for 6 months and only did one at the end. And that was the transcribing of the depositions, which I had to do. So basically, she didn't do anything
Okay,
in
now
6 months.
let's stick to your case and so at a hearing, she asked to withdraw.
I asked her,
You asked,
and the judge said, listen, we're not going to wait to the transcribing of your deposition. You have to withdraw now. So I said, fine.
okay. When did he have the Ferretta hearing?
Right after.
And you didn't have a lawyer, and you didn't know what a Ferretta hearing was, and you didn't ask for a Ferretta hearing.
No.
Okay. Now usually...
But he said the law requires him when... and remember, he said that he asked if I wanted an attorney. Listen. I told him that I didn't want an attorney because he told me he wasn't going to appoint me an attorney. He says, under no circumstances, basically, this is your last attorney. So instead of angering the court, I just went along with him just to get this out of the way. Just to get this out, because remember, when you're leaking blood, as it were, and you're wounded, you don't want to sit there and argue with anyone. You want to heal the wounds.
Okay, you're a veteran, is that
Right.
correct?
Mm-hmm.
And you have a lot of medical issues
Yes.
because of that.
Right.
And I just wanted to raise, and I guess I want direct answers.
Mm-hmm.
You asked, he basically allowed you to go pro se, is that correct?
Yes.
Okay. Next, you put in a motion, well, he also released the attorney and had a Ferretta hearing, and you didn't know about that Ferretta hearing.
I didn't. He basically was saying that he has to see if I'm competent,
Okay.
where I could represent myself.
Okay. Now, I'm going to stop you at this point. Now, soon after that, you asked that he recuse himself. That means that the judge moves himself out of the case, and 3 other judges have. Is that correct?
Well, in my case, the first judge, and this is very interesting, the first judge I had was C. Jeffrey Arnold, who I had filed a complaint with the Florida Judicial Qualifications Committee because I felt that he was hindering myself in terms of having a fair trial. But he was removed not because of my complaint, but there was a couple other incidents that happened. The Supreme Court in one case said that Doug Geslow of Axe the Tax said that you couldn't send this guy to jail. Well, that judge said he didn't care what the Supreme Court. He sent him to jail for 60 days. Next thing, while that...
let's see if we can convince.
Right, yeah. The next thing, the prosecutors and the police asked him, do not let Jesse Davis out because he's a danger to society. The judge says
Who is Jesse Davis?
Jesse Davis was the guy who was charged with assaulting an individual. And he was playing like he was crazy. So the judge says, I don't care. So he allowed the guy to come out as long as he took his medication, went to the doctors, and went to the probation office. Within 45 days of coming out of jail, he murdered 2 teenagers on Cadyway Trail and set their bodies on fire. One of the kids was the son of an investigator with the state attorney's office. They moved him out so fast from Orange County to Osceola County, I didn't even realize that. That was the first judge. The second judge came directly out of the state attorney's office, which I immediately, in my court-appointed attorney said, is a conflict of interest. Because he was in the office while my case was in the office with the state attorney. And so we put it in the record. I said, August 28th, 2012, I want you to recuse yourself. It took him over 2.5 years to recuse himself when I found evidence that he was training the police that did the raid in my
Talk
case.
about
So he withdrew from the case.
whether the police acted appropriately.
Right.
Okay?
Mhm.
Now, in any case, let's get back to the Ferretta hearing. You went through it, the judge said that you were competent.
Mhm.
Okay. Soon after that, you filed a motion to have the judge recuse himself.
Right.
Is that correct?
Correct.
And what did the judge say?
He said that my motion was legally insufficient on its face.
Now, does that make you qualified to defend yourself in a hearing?
Well, obviously, what he said was that since he alleged that the motion was no good, that I basically didn't know what I was doing.
Okay. I wanted to get that on the record. And I don't know what other hearings you've had, but I was at a hearing today where initially he said, I'm not going to appoint you a lawyer, and you described that the prior lawyer really had medical problems. And sometimes I like to ask judges, if your child was in front of a judge, would you take that attorney? And I can't ask judges of that, but the answer is pretty obvious. Many of them would say, no, I want the best. Today in court, the judge said that selecting attorneys is a crapshoot.
He did say that.
Yes, he did. And
Yes,
I have notes. I can't really refer to them at this point. In any case, after you spoke about the issues and the other attorneys, he relented. And instead of saying he wouldn't appoint an attorney, he said, well, this is the last one. And that sort of disturbed me because there are so many attorneys who aren't going to spend the time, are not going to get paid to get researchers or investigators. So it's not just the attorney. You can have a very good attorney, but if the court system ties his hands behind his back, that's going to be a problem. After you left, the judge asked who I was. And I told him I put internet videos on, and I put them on YouTube, and I put them as Irwin Ironstone. And I'm only doing that because I expect this to go up, and this interview. There are a lot of other things that happened. I don't know if you can tell me a little bit about what happened in court today.
Yeah, I can. And the judge was very clear to correct me. It was my interpretation that we had sort of like an adversarial relationship, but he made very clear that he felt that we did not, and that he didn't hold anything against me, but that he just wanted this 6-year-old case prosecuted.
Okay, I was in the court at the point that he was talking, his voice raised, he raised his fingers as if to say, don't accuse me. And one of the reasons I raise this is I've often thought that having cameras in all courts would probably be the best because it's the best available information. And I have a couple of papers on why cameras should be used in court on academia.edu, and it's under Irwin Ironstone. And there are a group of writings there. One of the other things, we went to the court administrator, I don't remember her name.
Levy.
Levy, okay. And I asked what it would require for me to video. And she said, first you have to be a certified reporter. And I asked her about something else. Evidently, they schedule things for the stenotypists.
Mm-hmm.
And as an example, they also have the ability to do audio recording. And the difference in getting a stenotypist has some advantages, but for poor people, it has lots of disadvantages. How much does it cost you to get an audio disc of a court hearing?
$15.
Okay. I just had a 6-hour hearing, and it was $950 because the judge and the prosecutor refused my motion to either record it or to videotape it. And I asked the judge initially, would he grant a stay so that I could appeal it? And his response was, appeal it. In other words, he was dragging me through this, and he's a judge from Miami. I won't indicate his name or the type of hearing it was, but it was like a witch hunt. And I'm concerned not only for myself, because I've seen lots of judges lie, lots of prosecutors fail to do their job, and there's a U.S. Supreme Court case from, I think, 1923. It's called Berger versus U.S.
Mm-hmm.
And that case says prosecutor's job is to investigate. And it's not just to find someone guilty, but to find if someone is innocent also. And I raise these because I tried to raise issues in my case. And in my case, the prosecutor, who is a retired judge, said the information I wanted to raise couldn't be raised because of a legal rule called stare decisis, which means the decision will stand. Even though, in my opinion, and I think if I showed it to other people, there was fraud committed in my case. So I have to then say sometimes stare decisis doesn't work and shouldn't be used. Okay, anything else that you'd like to talk about as far as things that happened today?
No, I want to make it clear that I don't dislike any officers of the court. I respect Circuit Judge Mark L. Lupit, and also the administration, and especially those that are down there where in the clerk's office where I file a lot of motions and stuff. They're very professional in how they handle themselves. So, no, I'm appreciative that God has allowed me to have another attorney. This one, the one that I have now, I've met him several times, so I know him, and I've seen his work. But it remains to be seen what will be done in my case. I hope what Mr. Morano has done before, that it will carry on with my case.
Okay, the judge raised a Supreme Court case called Strickland versus Washington.
Mm-hmm.
And Strickland basically, I think, stands for the fact that if you're not given a competent attorney, the case, I believe, can be overturned. And it gives certain rules, and there are other cases after that. And I'm not sure, I'd have to look up Strickland and read it in order to make, a better analysis. But the judge did reverse what he initially said. There were a few things that I didn't like because effectively he didn't allow you to get transcripts. And sometimes transcripts are reasonable because I don't remember from one day to the next what I have for breakfast. And these transcripts are from years ago. And I'm sure if the judge would listen to them, or Easy would listen to them, or read them, they might refresh his memory. And that's allowed, but in this case, the judge refused your motions.
Yeah, I anticipated that because he called me in for a hearing. It's important that for anyone that has anything before the courts, that at minimum you want to be able to get the CD and pay for it, and so that you can hear what is being said. Sometimes things move so quickly that you don't actually hear the things that are being said, and often there's things that the prosecutor may say that when you go back, there might be some type of violation and so forth. You know, my case is in its 7th year. It's in this 7th year for a reason, and not because anything that I did on my part to try to delay it. No, I didn't use any delay tactics, but you used the law. I think the judge knew today that the fact that the Supreme Court had already suspended this attorney for
That's the Florida Supreme Court.
right, Florida Supreme Court, for violating the conditions of her probation, and so they brought in an expert, and they found out that she lied, and she admitted lying, and so if they would have refused to give me an attorney and they had proceeded forward with this, I think his 32 years as a defense attorney, he knew that I had grounds for an appeal that likely, let's say if I was to get convicted, would have been overturned.
But why would one want to wait and appeal an action
Right.
when
This is the whole reason why what I bought in court today, because
I want to ask you about that also. What about all of your medical problems? Because even if you can be competent, if you're taking medications.
I'm a disabled veteran, and I had PTSD, and I have a major depressive disorder. I have major depression. And for many of us veterans, you know, the doctors will try different things that may work and may not work. And so it's like a crapshoot, as they often say. And so I've had some adverse reactions to some of the medications. And often what this does is that it leaves you with the ability to concentrate.
What about...
And it takes your energy away.
Okay, what about your prostate?
Right, I'm going to have surgery here within the next week and a half or two. And so that's been an issue, an ongoing issue that, you know, having that problem, for most guys that really have severe problems, they also have insomnia, they can't sleep.
Well, you have to get up to...
You have to get up 10:50, and people may not, there's times when I had to literally...
Take that away.
Yeah. There was times I had to get up 25 times. And it drives you crazy. And so...
And you're not alert.
You're not alert.
And
you can't, and you don't have the energy, let alone to do anything than try to work on a court case, because you can't focus, you can't concentrate. And then you just multiply this every day. And so you can't, you know, to work on a case, a 7-year case, what is voluminous as my case as well, the files.
How old are you?
I'm 57.
Okay. Have you ever been involved in actions like this before?
Never. And I will say, this was the first time in my life that I was arrested on this case. I was 50 years old, never been arrested in my life. And all of a sudden, I'm going to win this election. I'm running for city council. And they've been trying like hell to set me up. And I even sent the letter to the police chief telling her that you guys are trying to set me up. And sure enough, this is exactly what they did. And then they needed whatever they could do to get me knocked out of the race. The whole thing here was, it wasn't so much of a drug investigation as it was in political prosecution or persecution. Yes.
Okay. And one of the things that they've done to you, I don't know what happened before. I haven't really known Easy for any period of time. I just am sort of going through a few things. I was going to say, what impact on your political career has the 7 years of prosecution had?
No, you won't have a political career after this. And now, what one needs to know is what it does to you emotionally and psychologically, what it does to you financially. I hadn't worked since this happened. And then I was the victim of identity theft. As soon as the police arrested me, within 2 hours, someone was using my wallet. They had stolen my wallet, or the police did not return my keys to me. Someone got into my office, who the police gave the keys to.
Well, I can't.
Without my
say
permission.
that.
Without my permission.
Okay, the police. How do you know the police gave the keys?
Because they were the keys were in their possession.
Okay.
And then the individual involved, we were able to have witnesses that identified the people that were going in, and so they tried my credit cards while I was in jail.
Okay.
And that went to internal affairs. The long and short of it was that they compensated me on the bank gave me the money that was stolen out of my account. The police or the city of Orlando compensated me on a few things that were not returned to me, but this gross negligence on the part of the police was, to me, spoliation of evidence. That means that you can raid a house for whatever reason you want to raid it, but you can't leave it in such a condition that it can get burned down or someone can come in and steal. And so what I had alleged was that there was evidence that could help my defense that was stolen out of the office.
Do you know if they had a search warrant?
I believe they did have a search warrant.
Okay. After a search warrant, even if they enter, then they have to lock up the premises.
Well, that didn't happen. And let me tell you something. When they came to my office, I had a newspaper reporter there interviewing me. They opened the door, looked me directly in the face, and threw in one of those explosive devices, and then they broke out all the windows in the front. My door was unlocked. They could just walk right in. It was me and a newspaper guy. There was no need to break any windows.
Okay, so you believe that was improper.
Oh, they knew it was because they had been there before a year prior to that, and I invited them right in. The police could come to my office anytime. They didn't have to. There was no element of surprise. What they wanted to do was they wanted to really inflict as much damage and loss.
What type of emotional impact did that have on you?
Well,
I would be very, very emotionally upset.
well, remember I had never in my life been arrested before, and here I'm being housed in the jail with murderers, baby killers. I've seen them all down there, and it was like, wow.
They didn't keep you separate from them?
They did initially when I asked for it, but they had what's called
Holding pen.
they have a protective custody for high profile cases, but they had a couple in that cell. You're in there 23 hours a day, and you're just separated from people. And then I had some very undesirable people that were in that area that I didn't want to look at.
I'm going to jump because you told me a few things, and I think we'll wrap this up because we've probably been at it, for an hour. You said you were locked up for 70 some odd days?
Yeah, this was from December 15th, 2014 to February 27th, 2015. And it was a bogus failure to appear. It was a capias that was issued by...
What is a capias?
A capias when you fail to appear. It's a warrant for your arrest.
It's a bench warrant.
Right. And I didn't even know what the word meant at the time that it happened. But what had happened was my lawyer gave me, my court-appointed attorney gave me permission to go to my doctor's appointment that he would cover and tell them that I was being evaluated. And when he goes to court, he pretty much tells the judge that I'm AOL.
Was this one of the court appointments?
Yes. So he tells the judge.
Has anyone done anything against this? Was there any charges made?
No, I'm going to do that as soon as I can get this thing, because, and strange enough, he tried to contact me the other day, but I will not answer his.
There's a problem because
Right,
the
right.
statute of limitations for this type of action will run out.
Right, but what he did was the court-appointed attorney lied, and I have his.
Oh my! He lied.
I have his text messages. And one thing I would tell people is that when you're dealing with your attorneys, the court-appointed attorneys, get everything in writing, and if you can't get it in writing, have them leave it on the recorder or a text message to you. But you just can't take people's words for it. But the long and short of it was, I had never missed any court dates. I remember at that time I was in it for over 5 years. Why would I all of a sudden miss a court date after 5 years?
Do you think that lawyer knowingly contacted the judge? Well, I can't say knowingly.
No, he went to court that day. What frustrated with me because I refused to take the plea deal. He says, "I've been working high and low to get this plea deal from you, and you would do this to me." The plea deal was 2 years community control followed by 20 years probation. I don't consider that a plea deal.
Okay, I just wanted, and I think we've spoken enough for a first video.
Yes.
And thank you for making
Thank you,
the video.
Mr. Ironstone. Thank you for coming down to the court today. You really made a difference.
Okay.
I appreciate that.
That's the
Thank you
last
so much.
thing. I think you need to have witnesses.
Oh, you need to.
Or you have to have all of this
Someone there with you.
on camera.
Yes.
And that will get another video that we'll talk about later. Last time to say anything.
Thank you for listening.